Personal use. Yeah.
Well, hey, I think we are live here. I have the infamous, he would say famous, but the infamous Stephen Palmieri, and we have Robert Sigmund on here also. And Robert, we'll let him introduce himself. And we asked Robert, we sent him a message about 2 months ago to get ready for this day. I mean, it was 2 minutes ago. I'm sorry.
That's right.
2 minutes ago. But Robert keeps up with a lot of the litigation around credit repair cases and credit repair companies. And so we thought it might be interesting to get an update from Robert. And so, Robert, if you want to introduce yourself, and then we'll hear from our esteemed Stephen colleague here, and then we'll then pivot back to substantive matters and hear from you, Robert.
Sure. Yep. My name's Robert Sigmund. Like John said, first, I appreciate you guys having me on. I don't know what I'm going to contribute, but I'll go through some of the stuff. But as an introduction to me, I was in the credit repair space for about a decade, got really concerned with some of the consumer protection laws and the regulations and how they apply to how they affect the business of credit repair. And I ultimately determined that it's probably not possible to comply with some of these rules and laws. So we started looking through ways to do that, and we came up with a platform, and we run a compliance platform now. So what we do is kind of, the reason I'm up on all these laws, like you mentioned, is because I'm constantly ripping through everything, handing stuff off to attorneys to figure out a way for this industry to continue, given the regulatory environment that we face. So yeah, that's my history. I was in the industry. And then we went from providing credit services to providing compliance to credit services.
Okay. Well, thanks, Robert. And I see Stephen fell off.
Yep.
And I was doing a webinar earlier today, and my internet went out. So I don't know if there's some rolling internet outage here, but hopefully Stephen will jump back on. So, Robert, what's the name of your company?
Credzu, CREDZU.com.
Okay. And what we had mentioned to you, before we gave you all this notice here, before dragging you up on the stage here, is there's a couple of cases that have some pretty big significance to credit repair companies. We have the Credit Repair Cloud. That's the big software company. I don't know, thousands of users, maybe 10,000, whatever. It's an enormous amount of users. And they've been sued by the CFPB. Is that right?
That's correct. Yep. They've been sued by the CFPB. We got trouble back here. So we're back in business here.
Little space alien abduction, but I'm back here in time. So don't worry.
So the CFPB sued Credit Repair Cloud and said, hey, you violated some various rules like the telephone sales rules. And I think there was a motion to dismiss filed by Credit Repair Cloud, and then that was ultimately denied. So the case is moving forward.
That's right.
What's the current status of that case as you've been watching it?
Yeah, and then just want to go back one thing. They technically didn't violate the telemarketing sales rule. So they provide software, and then they have users of that software. The users are the ones that are violating the telemarketing sales rule by taking advance fees, such in violation of the 6-month rule under the TSR. So the users are violating the TSR, and then the software company is getting hit under the TSR for what's called substantial assistance. And if you have someone violating the TSR and you substantially assist them in that violation, then you're just as liable as they are. So technically, they're not the one violating the TSR, but they're being sued for substantially assisting people that are violating the TSR. And as far as the case proceeding, you hit the nail on the head. There was a complaint. There was a motion to dismiss. Their motion to dismiss was denied entirely. And they actually answered the complaint, which is weird. I thought they'd probably try some more, at least motion practice of some kind to kind of limit some things, but they just went straight into an answer. They did an answer in affirmative defenses, and I suppose it goes answer, answer, and then reply, right? So complaint, answer, reply.
Yeah,
so
there typically won't be a reply. It'll go into discovery. So exchanging information, taking depositions, putting people under oath. So that's what should be coming next? I'm sure
Mhm.
there will be lots of battles between the government
Sure.
and the software company.
Yeah.
It's a pretty interesting theory, this sort of substantial assistance.
Mhm.
Um, so what's been going on with the end users? Are they getting brought into the suit? Are they being subpoenaed? What's going on with them?
Yeah, so there is, and Brian Ponder's dealing with some of the end users, the credit repair companies. I don't know to what extent they're being brought into the suit, but I'm just guessing based on some of the stuff that I'm hearing that they're being brought in and they're being hit with subpoenas in order to testify, I think, against Credit Repair Cloud. I don't think they're getting directly hit by the CFPB. In other words, I don't think the CFPB is suing them for any violations that they may be involved in. But it seems to me that they're basically just getting the credit repair companies to write, whatever they're going to do. They're going to get them to testify against CRC, in my opinion. That's, again, I'm just kind of guessing, but that's what I think is occurring. And then that would kind of make sense because their case is you helped them violate the rules. So they're really trying to kind of pin it on the software, because they kind of went a little further than just software. They kind of trained and provided advice on how to do things. So I think that's kind of the case that the government's trying to make.
And let's take a step back, and we've been throwing around some terms, this sales rule and something with the telephone and 6 months. And for those in the audience that maybe are not up on that, give us the 2-minute version of what law are we talking about? And as a practical matter, what does it say?
Sure. So, just backing all the way up to like the 80s really quick, there was, the FCRA came out and there was an ability for consumers to fix stuff in their credit report by challenging the accuracy. And then that opened up a market of credit repair companies that said, hey, I'll help you do that. And then there was no regulation whatsoever. So a bunch of people flooded into that market and there was a ton of harm in the credit repair industry. So from day number one, the government's like, oh, this industry is problematic. And they regulated the industry. They did it through what's called the Credit Repair Organizations Act, which is a federal law that regulates the credit repair industry. And then there's also state laws that do similar things. But the rule that you're talking about, the telemarketing sales rule, it's a much larger piece of, there's a telemarketing law, and that's a larger piece of legislation, and it gives the FTC the power to create rules. So the FTC created a rule called the telemarketing sales rule. And that rule typically goes after abusive telemarketing practices, and they have some specific industries that are delineated in the law itself. So they did that. But then there was this provision in the TSR that says, by the way, and other abusive acts and practices. And when they were given the power to do other abusive acts and practices, the FTC said, cool, credit repair is on that list. So then they created a special provision inside the telemarketing sales rule directed at the credit repair industry. And in a nutshell, that rule says you have to perform the work you promised to the consumer. You have to complete that work, so however long that takes. You have to wait 6 months. Don't charge anything, but you have to wait 6 months. Then at the end of the 6 months, you get a credit report that shows you did what you said you were going to do. And at that point, you can charge the consumer. So that's a quick history, and that's basically what the TSR says. It says more than that, but that's essentially it.
Okay. And then I think there's another case that's getting some attention, and I was not familiar with this case. I just saw something on a Facebook group that you and I are on that probably Stephen Palmieri has something to do with. But despite that, it's a very useful.
Creditrepairtrainingcourse.com for those of you guys. Go ahead and check it out.
And so what is that? Something credit game or like that?
Yeah, credit game. There's actually a lot of cases that people probably don't know about. There's like Key Credit Repair. There's the Lexington case. There's Alex Miller Credit Repair. And then obviously the credit game as well. So the credit game, it was run by a guy named Mike Rando, and he actually ran a credit repair company, a funding company, trade line. He had did all sorts of stuff. He was in the industry directly providing services to consumers. And then he decided to get out of the industry. But really all he did was kind of just change his name and kind of the model a little bit. At least that's what is it the FTC or CFPB? I think it's the FTC. Yeah, is it FTC or DOJ? Oh, sorry. Alex Miller is DOJ. FTC is the credit game. So they basically said all he did was rebrand, and then he had this educational platform so people could come in, learn about credit and things like that. But then he would just outsource the services to somebody else that performed the services. But supposedly he was involved in that. I'm not quite sure. At the end of the day, they sued him and his company for the same thing they sue everyone for every single time: violation of the FTC Act, violation of the Credit Repair Organizations Act, and violations of the telemarketing sales rule. So it's pretty par for the course. They're being pretty aggressive right now, and they're using the same rules over and over and over.
Okay. And are you seeing anything that is unusual or out of the ordinary that either the FTC or the CFPB, Department of Justice, anybody at a federal level is bringing?
Yeah. So in the Alex Miller case, that's a little out of the ordinary, and Brian Ponder is doing a good job of defending that case as well. It's the DOJ. So instead of FTC suing you or, some AG suing you, it's actually like United States of America suing you and the Department of Justice coming after you. And there's no FTC or CFPB involved in that case that I know of, that I saw anyway. So I think that's kind of interesting. I think if the DOJ is involved, they're probably looking at some other stuff aside from just the violations of these credit repair regulations. But again, that's just me assuming. So I did find that that's kind of weird that the DOJ, I only know like one or two other cases where the DOJ got involved in the credit repair case. So I think that's certainly out of the ordinary. Not necessarily out of the ordinary, but I would just say that the entire enforcement right now is just off the charts. It's not like a blimp on the radar. It's more like a tangent to a parabola. It's just like shooting through the roof. Tons and tons of enforcement. And then the other thing is, instead of just going directly to individuals that are violating these rules, they're kind of doing, not choke point, because they're not supposed to do choke point, but I mean, when they went after CRC, they effectively went after a group of nearly 10,000 credit repair companies. So I'm seeing some of that kind of stuff. And there's something going on right now that I don't know is exactly public, so I probably won't go into it, but I'll say there's another CRC type organization that revolves around credit repair, and their voicemail right now says, we can't answer you because we're under a court order, and we'll get back to you soon. So they are definitely increasing enforcement actions and going after large entities that kind of include a lot of credit repair companies.
Stephen, what questions do you have for our esteemed colleague, Robert Sigmund here?
Well, maybe it's not a question, but more an observation. My esteemed colleague, Robert Sigmund, from what I've been able to ascertain from you with all of your TSR knowledge, is that it's almost impossible to operate within the TSR. You want to operate outside of the TSR. Is that basically the position that you take?
Yeah, for sure. And by the way, I'm not saying that's the only position. I'm saying that's the position that we're comfortable with after years in research on this. There are limited ways to comply with the TSR. Like, you could, if you did what the TSR specifically and exactly says, you would probably be out of business, right? Like, if you can comply with it legally, but how are you going to do the 6-month wait? It's much longer than a 6-month wait. So I don't know the practical ability to comply with the TSR as is, but there's also, there's exemptions in the TSR if you meet face-to-face and things like that. But I think the compliance as written, it makes up a very small segment of the population of the credit repair industry. And I'm sorry that this might get into a longer answer, so I apologize. But if you look to the abusive practices that they were trying to regulate, the TSR doesn't even regulate credit repair. The TSR regulates abusive telemarketing practices. So they go credit repair industry using abusive telemarketing practices, and then they created a rule specifically for that industry. So if you look at the TSR, it's the telemarketing that's the problem, because they And there was actually a really good quote from the CFPB that basically said, the abusive practices related to credit repair are increased when those abusive practices are sold over the phone. So the way we looked at it, we're like, fine, get rid of the problem. The problem's the phone. And I know Steve is going to cringe when I say that because he loves his phone. But the problem is the phone. And if you even go back to like the 90s when they were promulgating these rules in Congress, before even the FTC got to the rules, when Congress was talking about it, they talked about their concern with word pictures and lying and implications and things you can't really say, but you can convince people to buy stuff that they might not have ordinarily purchased. So they hate phones. The government hates phones, in especially these types of industries where you have, consumers who are financially compromised, credit compromised, maybe a little desperate, and they'll be more willing to take on a lie. So anyway, to answer your question, yeah, we say get off the phones entirely. Look, what year is this? Just why do we need like 1986 methods of doing business? Just get off the phones, do internet only signups, and avoid being subject to the TSR in the first place. So that's kind of the model that we're advocating. There's other models out there. There's other ways to comply with it, but we just felt we did not feel comfortable, A, being on the phone, and B, anybody that's using our escrow services, we don't want them on the phone either, because we don't want substantial assistance. We don't want them to be whispering sweet nothings to people on the phone and that we can't, hold them accountable for. So yeah, we're not a fan of phones. We don't like phones, and we would prefer if people just got off the phone in this industry, and just move forward with different methods. One quick thing, I'm talking about phone sales. So past the sale, you can get on the phone with somebody and talk to them all you want. But the government doesn't like you talking someone into something on the phone, especially something that's so sensitive like this, where people are likely to believe maybe some exaggerations.
There's an expression that people have when they follow their own advice. It's called, we eat our own dog food. And so just to demonstrate that, at I guess 3:58 Central Time, when Steve and I were like, what are we going to talk about? We said, we ought to get Robert on here. And so Stephen's like, let me message him. And, we didn't call Robert because, he wouldn't answer the phone, but he was monitoring his chat. So,
yeah.
He practices what he preaches. I guess.
So if I could chime in, I agree with a lot of what Robert has to say. I do think people would much prefer to engage and purchase without the phone, right? But the issue, I think the real issue for the practical application for the average CRO out there is, okay, I guess there's a couple parts. Number one, being able to invest in getting websites, landing pages, and all that kind of stuff, right? But let's assume that they have that. If you're established, people are just going to be calling you, right? And so then you said, well, you can close the sale over the internet or whatever. But my understanding is if they call you even one time and you direct them, that would trigger TSR. Is that kind of a fair statement, Robert?
Yeah, I don't know the answer to that question. We have tried to research that, but it's such a weird little sliver of a fact pattern that there's no guidance on that whatsoever. We take the position that even if, let's start with what triggers the TSR. The answer is any plan, program, or campaign designed to induce the sale by use of an interstate phone call, right? So there's a word, induce sale. So if you are literally talking someone into buying something on the phone, you're definitely triggering the TSR.
Well, then that means I'm good, because I usually try to talk them out of doing business with me. So, then does that mean I'm okay if I'm talking about?
No. So, and here's where I'm going with this. I would say, even if you said, hello, go to my website, goodbye, I wouldn't even touch it. And here's why. There's what does it say in there? Any service represented to improve credit repair. So there's all these things, like once you take that word and you unpack it, and then there's net impression analysis and blah, blah, blah. And it's just like, yeah, you probably represented it somehow. You probably said, hello, this is Steven's credit repair. Boom, done. You just represented that you're going to improve credit. So I say, just for the purpose of a sale, just get the hell away from phones. Just don't do it. You're going to open up a huge can of worms under the TSR. And I'm not saying let me be super clear. I'm not saying try to sneak around these rules. What I'm saying is remove the behavior that the government is concerned about. And the behavior that the government is concerned about is talking on the phone and making some kind of misrepresentation or some kind of inducement that you can't live up to. So get that off the table. Take the government's concern away. Get the client to read the contract or the terms or whatever you're representing that you're going to do online. Click. They can sign a signature with their finger on a tablet and be done with it. Then get on the phone, talk all day long. You can talk. You can do education, all sorts of stuff.
Yeah. So I mean, for the average viewer here, well, I guess we have lots of viewers because we're piped in through John's YouTube with a lot of consumers. But for the average CRO viewer here, whose phone rings all the time, so what would you suggest would be a practical pathway forward to,
that's a great,
I guess, quote unquote, get them into compliance per, what you believe it would be?
Yeah, it's a great question because there's part of it's kind of like a legal question. You need to go to your attorney to get legal advice on like how you do it. There's also kind of like a business practical.
The business practical is kind of what we're talking about here.
But there's kind of a gap there, right? Because like you can't just jump in. You'd probably kill your business. You can't just like drastically change something like that. I would say this, and I'm kind of not saying this, but maybe I'm kind of like winking at you, and maybe you can listen between the lines. There's cases that say if you can show a trajectory of trying to come into compliance, sometimes the government's a little bit lenient, right? So I would say start doing anything you can to come into compliance with these rules right now, whatever, even if it's a little tiny step. Start documenting that stuff, start documenting your intention to do things in the future, and then slowly start moving into a compliant model. That's what I would recommend. If you want to talk about what our model is, you can definitely contact me. But there's a lot of, compliance attorneys out there that can also talk to you about your specific situation and how you can address it. Because by the way, everyone's so different. Like, are you going to sell in every 50 state? That's a big deal. Are you going to sell in just one state? That's a separate compliance discussion, So generally speaking, we have a compliance platform with escrow and all that kind of stuff, but also like everyone's situation is a little bit different. So they need advice from an attorney.
Yeah. And so with what you guys do with Credzu, I mean, you kind of more provide the omni-channel platform. I mean, like if somebody's like, hey, I don't really have landing pages and all of that, you don't really, can your company help with that? Or are you kind of like, hey, once you have that, or, then they can dump into my thing, but we can also wire up to your Facebook and I guess your text message. So how can you, with what you've brought, because obviously you put your business together completely around TSR. So, I mean, how could the kind of the average, one or two man show CRO who doesn't have a whole lot of resources, how could you help them?
So if they don't have a lot of resources, whether they have a lot of resources or not, we kind of offer them the same thing. The first thing is there's going to be like a sign up page so it'd be credzu.com/whatever your company name is. And you can direct traffic there. And there's a sign up form. It's very simple for them. Those people get sucked right into the system. You get pulled in, the consumer gets pulled in, an escrow agent gets pulled in, and everybody works in the centralized system through chat until an agreement is signed. At that point, you can get on the phone. We do have push notifications, but they have to kind of register for that. We have text messaging, we have emails, and obviously no phone calls. We have not had anyone try to use the Facebook stuff yet, but it's very easy. We could easily do it for you. We use a thing called Twilio, if you're familiar with it. It's an omni-channel communication platform. So yeah, we can pull them in any way you want, except for phone, obviously. No phone calls.
So then what type of channels integrate with your system currently?
What's being used is text, email, and push. Those are the three primary things being used. But if you go to twilio.com and ask them all the communication channels they have, we can integrate any of those.
Right. Yeah. Sure. Okay. So typically they would they've kind of have like maybe a separate phone number for text apart from their cell phone. I mean, a lot of people, let's just be honest, operate off their cell phones, right? And so that's the kind of client that I just have in mind as we're having this conversation. So they would kind of have a separate, like a VoIP, I guess, like a Ring Central or something that would plug in, or I guess Twilio, I guess you run it through there, but they would need to have a separate text number, right? I mean, to kind of run it through there. Is that correct?
This is getting super technical. I'm happy to answer. But so there's two ways that it occurs. Number one, the system, Kredzu system itself sends out text messages in the form of like a notification. Hey, you have a client. Hey, your client asked a question or whatever. There's two ways to do it. Number one, we can say, hey, your client asked a question, get back inside of Kredzu and answer. Or we can do what's called piping, and the question itself gets sent to a text message, and then you can reply via the text message, and then the message itself gets sent back. Either way, it's all in the chronology inside of Kredzu. The best way to do it, in my opinion, is to get inside of the Kredzu chat and plug it in there. So there's just zero question. Like there's obviously, so.
Very, very cool. Good stuff there, man. Well, I know, Rob, you've been working on that for quite a while, actually. Because you used to run a credit repair business, right? And then one day you woke up, you saw TSR, and you're like, how can we put a solution together? Is that kind of the manifestation of Kredzu?
That's pretty much it. Yeah. And ironically, I found no way in which an individual company could do it. If they're taking phone calls, there's just no way. So that's why we were like, we realized that you had to kind of inject an independent, impartial company inside of the industry to kind of be a barrier between the consumer and the credit repair company. And there's some stuff that the FTC has talked about, and they favor that. They not necessarily that particular model, but they favor a disinterested third party involved in these transactions. So yeah, that's what we decided to do. Interesting
stuff. So, well, John, man, how do we get on this tangent anyway? We were talking about court cases, I guess, huh? My goodness. So,
Robert, if a credit repair organization or somebody thinking about getting into that business wants to get in touch with you, what's the best way to do that?
Do info@Kredzu. I'll put it in the chat. I don't know if this goes out to everybody, but info@Kredzu.com, or just go to Kredzu.com. I'll put it in there. See, that's right. Boom. I put it in the chat. I don't know if that gets published or whatever, but that's the information right there.
Okay.
So something else, Robert, that's kind of interesting, right? Because the TSR, if you upsell, that like triggers, right? Like certain things within TSR. And so one thing that I had thought about from the e-commerce side of things, I mean, a lot of products give like a free trial for a certain period. I mean, so I know you're not a lawyer, not giving legal advice. I'm just curious, like, if you have like a CRO contract that's like, look, we'll give you like a 72-hour, whatever, free trial or something that, which is like a limited free trial. And then from there, your trial ends, and then it triggers, which wouldn't really be the upsell. I mean, if you kind of go into it with like free trial and this, I mean, if that could be done without triggering the upsell, that could be one way to just tell people, look, man, just sign up right away, free trial, let's get on the phone. The question in that case would be, would that trigger, I guess, the upsell provision? Is that kind of where the issue would be?
So I'm just thinking through it. Okay, so yeah, like you said, I'm not a lawyer and I'm not giving legal advice, but I'm just kind of thinking out loud right now based on your question. So are you saying get this client to sign up? Are you talking them, get them to sign up in the initial part?
No. Like they come in, not right. So no telephone. They just kind of come in from wherever, non-telephone. And it's like, dude, I mean, what do you have to lose? Sign up, free trial of whatever.
I think that's totally fine.
Once they're signed up, then you can call them. But I mean, because typically after the free trial, it's still the same product. I mean, maybe this could be a limited version, free trial with a limited version of the credit repair, which would mean you can use Steven's telephone and talk to him. And then after that, after the free trial ends, then you can have like the full version.
If you think about your idea, the only difference between what you're saying is that you're just changing the price, right? So if you can get them to sign up for $1, why not get them to sign up for $500, right? So if you can get them to sign up online at all, just do the whole thing rather than like play the game or whatever. So yeah, I would use the same exact thing that you just said, but just with the full contract that doesn't change.
Yeah, I mean, so then the issue with that, I guess, would be, I mean, you probably wouldn't want to deliver like full-blown service for the free trial, right? And that's where maybe, that, of course, under CROA, you're supposed to give like a 72-hour right of rescission anyway, right?
Yeah.
But I mean, if you could say, hey, I mean, you could have like a free limited trial or, free trial of like a, like a limited version of it or something, right? Which is going to mean, you could talk to us and we can give you whatever, but we're not going to, process documents or whatever. Because obviously, I mean, you're not going to want to kind of be bound to do like full blown work. But I've often kind of thought over the last year as we've had these conversations, if there's a way to do something like that where it doesn't trigger the upsell, then you like literally have zero barrier to entry. If they're coming in from the web or whatever, it's like, dude, just sign up and we can have a call. So maybe that's something you could dig in a little bit, see if there's maybe some case laws around that upsell provision or something like that.
Yeah. So, and again, I'm just thinking off the top of my head, but I've seen a couple of cases where they try to do different like combinations of sign up procedures. One of the cases, a credit repair company sold a book for $1,000 and they did credit repair for free. And the court was like, well, would the client buy the book for $1,000 if they weren't getting the credit repair? And obviously the answer was no. So then the court was like, then it's just all the same thing. And then you're just selling credit repair.
I bet that was really hurtful to the author's pride to find out that they would not have bought his book for $1,000. Huh?
That's it. Yeah.
Well, and let me just say this, Robert, because something you said a minute ago, I think is really important. If you're trying to figure out some loophole, then you're thinking in the wrong direction.
That's right.
And this is from many, many years ago. I was looking at a CROA case, so Credit Repair Organization Act. And, there were, whatever they were, lawyers or credit repair people who were saying, well, we're going to offer educational services.
Right.
And, but we'll give you personalized help.
Mm-hmm,
and the courts go, yeah, that's cute. You can call it whatever you want.
That's right.
But you're doing credit repair for profit and you're subject to this law. And so we see this a lot in the debt settlement world. So we have these sort of bogus law firms. They pretend to be law firms. And because they think that gets them out of some regulations about debt settlement companies. And so they go, oh, well, see, now we've escaped all the rules on debt settlement. And but the truth is, we look at the substance, not the form. And so, what you're doing, and I've not researched this. This is, I sue credit bureaus. I don't advise credit repair companies, so this is not my thing.
Can you say it with a straight face? Okay.
Can you say it with
just a big old grin on your face like that?
I enjoy suing the credit bureaus. What can I say?
We're going in the wrong direction. I said say it with a straight face. Don't embellish even more. My goodness.
I love, but I've watched what you're doing, Robert, and I think it's very interesting. And when I first heard about it, I thought this doesn't sound right. This whole chat thing, but the more I've thought about it, I still don't know if you're right or not, but I do appreciate the authenticity and being very direct about, look, we're not trying to hide what we're doing. We're not trying to disguise. We're simply saying, we don't believe this is, I'm putting words in your mouth, but I think this is your position from Credsy. We don't believe that if you ignore the phone, that the TSR applies. And so build your business around this, satisfy the concerns of the federal government, and that increases your chances of not getting, a target on your chest. And so I appreciate that approach. And because so many people in this industry are trying to get way too cute, with the $1,000 book or the $500 book, and but we'll give you advice, or they say we'll do a consultation with you, but that's just education. No, it's credit repair. You're charging for it. It's credit repair. So.
Yeah, I appreciate the kind words, John. And I will tell you, I'm about to drop a quote in here. We didn't think of an idea and then try to wrap some laws around it and figure out a way to like shove our idea through the industry. It was the exact opposite. We went and navigated the law and said, okay, how can we do this? And that is that's how we came to, we didn't think of Credsy. We didn't create this like an inventor or something. We just followed the path that the government was laying out. And then we came to one of the conclusions, which was get off the phones, use escrow, and don't lie. That's pretty much our business model. But I'm going to drop a quote in here.
Robert, you took all the fun out of it, man. Get off the phones, don't lie.
I know. Tell me about it. John, if you could put, can you grab that and post that? I don't know if you can or not. Maybe I should go to Facebook and throw it in there.
Let's see if I can. I'm not seeing anything pop
Oh, it's
up.
in the private chat channel. He's got it.
Oh, wait, hold on. I can do it in comments. I can do it again. Here we go.
Oh,
Wait,
yeah.
nope, I can't do it in comments.
I think I could grab this here. All right. So,
All right.
Yeah.
We are navigating the internal StreamYard chat session right now.
I didn't even know we had a private chat.
Look at that. Yeah, you should have seen all the dirty things I was putting in there the last episode that you didn't see. My goodness.
Hey, this is good. I like how this covers up,
So this quote has, it came out in a 2017 case. It was the Lexington law case in Tennessee. And then that was like a federal case. And then another federal court adopted it. And I think this exact quote has been argued by both the FTC and the CFPB and quoted by at least 4 courts in the last like 3 or 4 years, or maybe more than that. 2017, I think, was the first time it came out. So it says, if a credit repair company is, if a company is both a credit repair agency and a telemarketer, it is required to comply with both the CROA and the TSR. On the other hand, if a credit repair company or credit repair agency does not qualify as a telemarketer, then it need not comply with the TSR. Only the CROA is applicable. So, and by the way, that's not just like, oh, cool, we got our little sound bite. Let's just run with it. There's a ton of legal history behind that quote. And it's if you trace down the history of the TSR, you'll go, oh yeah, duh. If you're not using the phone, you're not engaged in the behavior that they're concerned with, So there's a lot of history behind that. It's becoming a very well settled principle in law right now.
As I was reading that, it kind of reminded me of the mortgage industry like 6 or 7 years ago. If you guys remember, the regulators came out with what they called TRID. You guys remember that? TRID? Because when you closed on loans, you had the Truth in Lending Act, which was
yep.
Then you had RESPA, which was the R, and then like included disclosures with the ID. And like there was a whole lot of not so playing well together between what was supposed to be done under the Truth in Lending Act and what was supposed to be done under RESPA. And eventually they got the regulators to prepare what they call TRID. Like that's what all the mortgage guys called it. So as you kind of put it up there, it kind of made me think of that, like, if as an industry we can sort of organize, that may be a pathway forward, because we also have two laws and we have 2 regulators, right? We have the FTC and we have the CFPB. And, if we can maybe go to them and get our own version of that, which is like, okay, if you're a CRO and a telemarketer, how can you actually like reasonably comply? You know what I mean? Like, okay, well, if they call you one time and then you're like, here, go to my thing for future communication. Okay, well then you're cool, right? So I kind of, I was just thinking of that as you put it up like that. Like, there are precedents for industries lobbying and going to the regulators and saying, hey, regulator, what we're supposed to do under the statute doesn't really work very well in reality. And so how can we make that work? So,
right.
Looks like we've got to get our lobbying shoes on, huh, guys?
I will tell you, there are people in this industry that are looking to do legitimate trade organizations. So I think that might be something that is something that exists in the future. So,
yeah, excellent.
That's all I'm going to say on that.
There you go.
Yeah.
Well, Robert, thanks for the information. And we're going to try to grab some of these comments. You're welcome to stick on with us, or
I'll hang out with you.
Yeah, if you need to drop off at any time, just do that.
I got to make some phone calls.
Yeah, we heard your phone ringing, but I didn't want to say anything about that. So here's from Robert. So I do a weekly webinar, and my internet completely went out. And so Robert's very kind there. Let's see, Eric, we have after statute of limitation expires and you get sued, whose burden is it to prove the timeline? Has the consumer prove that? It's a really good question. So if you were with us at the beginning, you heard Robert talk about Credit Repair Cloud got sued. They tried to dismiss the case. Judge rejected that. And then Robert said accurately that they filed an answer along with what are called affirmative defenses. So affirmative defenses are things where, in essence, you're saying, well, even if I am guilty, here's how I get out of it. And so one of those would be the statute of limitation, which is the time period to sue. You say, well, maybe I am guilty, but you waited too long to sue me. So the defendant always bears the burden to prove an affirmative defense. And so it can be a little challenging. So the consumer, and if you're sued by a debt collector, the consumer would have to prove this. And it could be by showing, when your bank records show the very last payment, you can get records from the debt collector. You can look at your credit report. That may, let's say it's Synchrony Bank has sued you, or a company that claims to have bought the debt from Synchrony. Well, maybe Synchrony's still on your credit report, and they say date of last payment was, 2016. And perhaps your state is a 4-year statute of limitation. Well, that can be some evidence of it. So just remember that you can't just walk into court and say, well, I'm going to make the debt collector prove that, I made a payment within the last 3 years or whatever it may be. That's really your burden if you're alleging statute of limitation. You guys have any thoughts on that?
I think you covered it. You got the lawyerly answer on that one.
So this is going back, this is from Monster Misfits, when we were talking about, the phone and the FTC and Congress, being concerned about sort of the abuse with phones, and yes, extended warranty.
That's exactly right. Yep.
And if you think about, there are certainly a lot of laws, consumer protection laws, that really are focused on the phone. So the Telephone Consumer Protection Act, TCPA,
Mm-hmm.
The FDCPA, Fair Debt Collection Practices Act, a big portion of that is about phone calls and what is said in those phone calls, the frequency of those phone calls.
Mm-hmm.
Is there abusive language used in those phone calls?
Right.
And so I do think that Robert's identified this thread that runs through some of these laws, that the government is concerned about sort of unequal power here, and somebody with greater power being abusive towards consumers over the phone. And they're saying, well, if you do that, we're going to put stringent requirements on you.
That's exactly right.
In the industry, credit repair industry can say, well, we don't like that, or we don't think that's fair, or that's affecting our ability to make money. And frankly, none of that's supposed to matter to judges, because
Right.
judges are supposed to, just apply the law as it's written. And I'll give you an example. We have a case in the 11th Circuit, which is the federal court over Alabama, Georgia, Florida. And this case is on rehearing right now, but it's called the Hunstein decision. And it's where a consumer sued a debt collector because the debt collector sent the data for all their letters to what's called a mail vendor. So the debt collector doesn't print out 5,000 letters a day. They send it to a company. That's all they do. They print it out. And the consumer said, well, technically you violated the law. And the 11th Circuit said, we agree. Now, again, that the opinion's been withdrawn because the whole court is considering it. But they said, we know this is going to cause a lot of heartburn in the debt collection industry. And the opinion said, we suggest you contact your congressperson. We don't write the law. It's really not our concern. We're here to apply the law. If you don't like it, go talk to your senator, your congressperson. So anyway, that's just something to keep in mind.
As you were talking about all the laws that have to do with telemarketing, I'm sitting here thinking, and my phone's ringing and it says scam likely. So I upgraded this new iPhone, badass, whatever, and 2-3 months ago, and now T-Mobile puts scam likely when phone numbers come in. And I've Googled, I could not figure out how to do that. And I've seen the Ring Central, my VoIP, every now and then it'll do that. And I'm sitting here thinking, well, that's kind of crazy. But for the telemarketing, telephone, has its time come, right? If you run your business telemarketing people, now, half these people that you try calling, cell phone providers, the VoIP providers, I guess that's a whole other conversation. Is that even legal? If they put scam likely, are they defaming you if you're not a scam? But I mean, like, have you guys experienced that with your phone
Yeah.
provider? Because
There's
like,
this,
figure
there's
out how
a
to.
thing that came out a couple years ago. It's like ADP, this and that, or whatever. I don't remember the acronyms like that long. But they put like this like protective layer over all calls. And you have to affirmatively go create an account and get verified with your business accounts. And if you don't do that, then they kind of like not blacklist you, but you're definitely not in their good graces. And you got to pay it a little bit for it. I'll try to find it and then put it in the chat. But yeah, you actually have to kind of like prove you're not a scammer now. It's
Really kind of crazy, yeah. But I mean, that just kind of drills home, though. I mean, obviously there is a real world practical problem of CROs not being able to take inbound referral calls and stuff like that. But like, if you're out there really telemarketing, it's definitely a tougher market now, than it was before, because now you've got your cell phone provider putting in your brain, oh, I'm not going to answer that because it's a scam. By the way, we've got an attorney on here, and a really amazing attorney at that. So if they were to put scam likely on a phone number that's not a scam, do you think there's any sort of legal recourse that business potentially could do against that? Is that something you've ever even thought about before, John?
No, I don't think there is. And part of the reason we've got the TCPA for all these auto dialed or robo dial calls, and if you look at the stats, you think, okay, there's got to be a typo. There's no way there's that many, just millions and hundreds of millions of these bogus calls. And so the government has put a little bit of pressure on the phone companies to kind of step in there and be that layer of protection and help you to be able to stop these types of calls. And so,
well, John, clearly you're not the attorney I'll be hiring then. That's not the answer. I'm going to go attorney shopping, and you failed the interview there.
Yeah. Don't worry about who's right. Just find somebody that tells you what you want to hear.
That's right. Exactly.
Let's see here. We've got, what do you guys think about the bureau bullies and what they're teaching? I don't know who that is. I assume that they either do credit repair or they sell educational courses. I would just say, kind of based on what we've been talking about, if somebody's selling educational courses, like legitimately, obviously you can sell a book. Brian Ponder has a book out. Brian Ponder's a lawyer in New York who we've mentioned several times. There's nothing wrong with selling educational materials. Now, if it's really just sort of a sham to then sell your credit repair services, that can be an issue. I have no idea about these people. I would just say that whoever's out there teaching things, if they're saying, hey, here's what the Fair Credit Reporting Act requires, here's what it allows, be honest, be truthful, don't do anything that is deceptive or fake identity theft affidavits, then I think that's good. And if somebody is advocating something underhanded, then I would stay away from that. And let's see, somebody else mentioned them. Again, I have no idea what they charge. Let's see here. We got Carlos. Yeah, we're trying to do the fight here. Let's see. Adam says, bogus law firm put a lien on my house. Now I'm trying to get a response about who's the original creditor. So at least where I practice, to put a lien on your house, they have to have a judgment, which means they had to sue you first. And they have to get you served, get a judgment. So there should be something in the courthouse that would tie back to that lien. So every state can be a little different, but normally it's in probate court is where the lien is put on your property. Say based on the judgment received on December 15, 2018, and case number 1234. Go look up that case. And if you can't find that, get with the consumer lawyer in your state. They ought to be able to pull that up. And so you have to do a little bit of detective work, figure out who sued you, when were you supposedly served, were you really served? Because if you were not properly served, and this is kind of what Robert was saying about, you have to be a telemarketer or use the telephone for this law to apply. Well, to get a judgment, we have to properly serve people. So if you were not properly served under your state law, that may give you an argument to undo that judgment And if the judgment falls apart, then there's nothing for the lien. It's sort of like, here's a judgment, the lien sits on top, but you pull the judgment out, the lien falls. So I would just start with the probate court, find that lien. It'll take you to the court where the judgment happened.
And John, are there some exceptions to that? Like in the case of like a mechanic's lien or like a lien on someone's house for work or something like that, can't they just go straight into the lien rather than a judgment?
Yeah, so mechanics lien. So somebody doing work on your house, it could be an HOA. A lot of times
Oh, yep.
they can put a lien directly, um, and so that's a good point. It may not be a lawsuit. I guess what got me thinking that way is the question talked about original creditor.
On the law firm, yeah.
But yeah, it's I'll give you a sort of strange example. There's a major city where there's sort of a dominant pool company, and like pools in your backyard. And I mean, they had just millions and millions and millions of dollars of this, and they ended up not paying their subcontractors, and not finishing the pools. And so all these people had paid money to the pool company, and then the subs were putting liens on their houses and threatening to then, in essence, foreclose against them. So, yeah, if there's a lien on your house, you need to take that very seriously. See if it's a judgment. That's what I was talking about, what Robert's mentioning. Maybe it's from some, we say mechanics lien, but we're not really talking about like the mechanic fixing your car. We're talking about the plumber, the AC guy, the roofing guy. And so definitely check that out. And let's see. Nick says, think they would have sued you first. Yeah, that's kind of my thought. And then the response, they did because I didn't understand who was who. So yeah, I would just trace that back through the court. And if you need some help, a consumer lawyer in your state should be able to look at that pretty quickly and tell you, okay, here's who sued you. Here's the law firm. They're good to work with. They're kind of jerks to work with. They should be able to give you the lay of the land there. And let's see here. So who are the people who help with false information on your report? Just the FCRA. So I think what Adam's asking here is, if you have false information on your credit report, first of all, who helps you with that? And then is the only law the FCRA, the Fair Credit Reporting Act? So how would you guys answer that?
Well, if it's so you've got the FDCPA as well. If it's false, if it's a debt collector, and then, I mean, if it's false information reported with malice or willful intent to injure, the FCRA then enables the consumer to still use other common law like defamation type claims. But yeah, the FCRA would be definitely your starting point, and then you would probably want to tie in FDCPA, and then look at state laws as well. That's kind of what I would say on that.
And the only thing I'll add to that is some courts say that no state law applies, that it's what's called preempted or wiped out by the Fair Credit Reporting Act. And the beauty of the FCRA, Fair Credit Reporting Act, is if the violations were done willfully, which reckless, wanton, it's all the same thing. It just means more than negligent, but like the credit bureaus knew what was going on, or the furnisher of information knew what was going on, then you can get potentially punitive damages, which is really the primary point of using state law anyway. As far as who can help, the customers of Robert would be credit repair organizations. Mm-hmm. So these are people that you would pay a fee to. They would help you to dispute inaccurate information. You can do it yourself. You can go to lawyers who do this type of work. So there's a couple of options on what to do. And I would just say, kind of educate yourself on what your situation is, and if you get somebody to help you, make sure that you're very comfortable with that person, because just to be blunt, you're turning over all your personal information to them. So make sure you know who you're dealing with there. And let's see here. We have
Credit channel.
is from Texas, so you know some Spanish, don't you, Steve?
That means the credit channel in Espanol right there. Mhm.
Very good, very good. So let's see here. We have Robert. Since November 21, some companies where I've charged off debt have failed to notify the credit bureaus of my dispute, have not posted a notice on my dispute as required. I have sent both the original creditors and credit bureaus many letters notifying them this violation. They ignore me. Is my next step CFPB or court? So why don't Stephen or Robert, what are we talking about here? This notifying of dispute and dispute notification. What is all of that? And then we can talk about what's the next step, either sue or go to the CFPB.
Well, so I mean, I guess on the face of it, Robert has disputed the trade line with the credit bureaus, and the trade line has not been updated as in dispute. So then what you need to figure out is, which would not be accurate for them to continue to report a trade line that's in dispute and not to note it. So then the question is, okay, if they're charged off, have they been charged off and paid, or charged off and transferred with a zero balance? Now, so if that's the case, then the trade line is probably in like what's called like a final status with the furnisher, which means the furnisher really isn't supposed to continue to update the trade line, except that they are supposed to update it or verify it when that dispute comes in. So, I mean, either way, you would think that the trade line should be noted as in dispute. Now, the problem with this is if it's a charged off original creditor, you're not going to have the FDCPA because there's a nice little cherry in there that lets you, go after debt collectors if they fail to mark a disputed debt collection as disputed. So then the issue is, okay, well, what else is wrong with the trade line, I guess is what I would say. I mean, if you're just disputing it, like, please prove it or remove it, but you don't really have any sort of substantial dispute other than that, and do you have damages, right? Like, how has this affected you? If you've got damages, and if you've got other real issues with it, that's the kind of thing that, you could talk to a lawyer about. Per your post, CFPB. Definitely you can go to the CFPB. I mean, if you feel strongly that there's real issues, send a certified letter all the way up to the corporate executives at whatever original creditor company this is. But, so hopefully it wasn't just kind of like prove it or remove it, and they didn't put it in dispute. I mean, so technically speaking, that still is inaccurate reporting. But for, to really be able to kind of put the squeeze on them, I would say, what are the actual errors? And on top of that, like, how have you been harmed? Have you tried to get a mortgage or a credit card or something like that? And then you can put all this with your CFPB complaint if that's going to be your next step, right? So here's what's wrong with this. Here's how I put them on notice of what's wrong with this. And Mr. CFPB regulator, who's here to look after the little guy, here's how this is actually harming me. And if that still doesn't get you a resolve, you are in a much better position to talk to a guy like John, I think, if you really have bona fide errors and they haven't fixed it.
Yeah, I think that's good. And Robert, I don't know if you know this, but the credit repair groups that use your service with CredZ, do you know if they find a lot of success doing complaints through the CFPB, or I don't know how involved you are kind of in their business?
Yeah, we try to stay completely out of that, except that we monitor what they said with what they did. I will tell you, it's probably not the best idea, and there's been some stuff that has come out about that. And actually, I think it's the credit game case. I think they were filing false CFPB complaints. So you have to be really careful with that. If you're going to send something into the federal government, it better be accurate and legitimate, and don't screw around with it. So I would use that. Yeah. I would use that mechanism to the extent that you, like Steve said. So there's like a checklist. Did you even write a dispute sufficient to trigger the FCRA in the first place? Like, did you actually write a dispute to the creditor? If you did, and they didn't respond, then you start having some issues because they're kind of in violation of that rule if they're not responding correctly, and then move on to a complaint or hire an attorney. So in that whole situation, let's make sure there's actually a dispute. Let's make sure the dispute is legitimate. And if you're sure of all those things, then go ahead and move into that complaint to the CFPB, but be very careful with that. Yeah, that's all I would say.
Yeah, and I'll
I mean,
say,
go ahead. I'll say, I mean, I do CFPB complaints, but my disputes are legitimate, right? I mean, we're putting them on notice of errors and real factual stuff. So I wouldn't be afraid to do it, but I would absolutely heed Robert's advice. I mean, you don't want to, just like complain to the CFPB if you sent some like total garbage out there that, is something that like you're lying to the credit bureaus and things. That's definitely really good advice there, Robert, for sure.
yeah, and there's been I want to say it's 2 or 3 months ago, the CFPB came out with a report where they analyzed the complaints that come through them that go to the credit bureaus. And, the response rate is just plummeted. And so the CFPB is taking notice of that and kind of calling the credit bureaus on the carpet about it. But what the credit bureaus say is, look, we get all this junk. It's all fake. It's all from credit repair companies. And so we're just flooded with it. So do it legitimately, do it accurately, maintain your credibility. If you want the ability to go sue, you've got to keep your credibility. If the credit bureaus can say, yeah, but you filed this bogus police report or fraud affidavit, you're done. And it doesn't matter how bad the credit bureaus have messed up. You may have just gutted your case by filing something that is incorrect. Let's see here. This is an interesting question. Aren't we the original creditors because they use our social security number? So that's something that comes up. And, when we're kind of looking at, okay, I've got these errors on my credit reports, or I have these negative things on my credit reports, how can I fix it? And then you see something that says, oh, well, wait a minute, you're the creditor because they used your name or they used your social security number. So I certainly have some thoughts about that, but I would be curious as to you guys, what's your short response?
I think the consumer is the collateral, not the creditor. The consumer's credit worthiness is the collateral. They're not necessarily the creditor.
Okay.
So I've seen things like this. I still can't fully wrap my head around it. I mean, I guess, okay, so let me try to back up. So does this go to like some sort of like a high level constitutional Federal Reserve?
That's what I
like
interpreted as.
Federal Reserve notes or debt instruments. Like, is that what this thing ties to? In which case, I would say, good luck with that, because Federal Reserve notes are unconstitutional. But clearly, here we are 100 years later with them. So then the question is, if that's it, then I don't know. If that's not what you're saying, Social Security number is just an identifier for the consumer, which is the debtor. So, I've seen this stuff. I think it's a really good question, Adam. I'd actually love to have a dialogue and I know there's people like in social media that are like training this whole thing and stuff. I'm always thirsty to hear things, but do you guys have any more feedback kind of on what this?
That is the way I interpret it. I interpret it as like, get out of jail free card to debt because we're the original creditor. And maybe I'm going crazy here, but I'm seeing it as, aren't we the original creditor because it was us? We're the ones that created this credit, right? Is that what you're seeing it as, Stephen?
Well, I'm not sure. Like I said, I think some of this goes back to, if Federal Reserve notes are debt instruments backed by the government, which is backed by we the people, then we provide the credit backing to the government, which provides the backing to the Federal Reserve notes. I don't know. Like, that's kind of what some similar conversations I've seen on Facebook. I think they go down that rabbit trail, and I think it may be a legitimate rabbit trail, except that where do you go with that? Like, what? Do you take that before a judge? And because the implication is, well, then the Federal Reserve System is unconstitutional, which that has yet to be successfully tried at this point. So where do you effectively go with that argument if that's where that argument goes?
I see a comment in there that Adam did say, that it's correct. It goes the social security by way of the birth certificate, right, which is the collateral. So they're saying that they are the collateral, which I kind of agree with. You're the collateral, but you're not the creditor.
Yeah.
Yeah.
Interesting.
So I'll say this: there are different variations of this that come up every few years, and so sometimes we have sovereign citizen, we have admiralty law, and did you sign it in blue ink or black ink? Is it capital letters? Or and what happens is something gains popularity, and it's complete nonsense, and it gets totally rejected, and then it goes away for 5 years or 10 years. Then somebody goes, I just discovered the secret. It's all the same thing. It's just we could go back to early 2000s, we could go back to the 90s, the 80s. There's nothing new under the sun as far as this goes.
Well, and I guess let's talk about the practical application. I see there's a post right below it that says that's why I asked about the bureau bullies. That's what they teach. And again, I don't know who those folks are, but I mean, I guess what I would say, what's the practical application of this approach, right? I mean, even if there is some sort of basis to it, are you really going to get any sort of a data furnisher collector to be like, oh, you got me. Our entire financial system is built on a Ponzi scheme of corporate, the U.S. corporation. So that's, I guess, would be kind of my takeaway. If you're looking for some sort of like a applicable, legitimate takeaway answer is that the best bullet that you have in your gun, to the proverbial gun, but to argue this thing, to shoot at the enemy, and what do you do with it, right? Like I can't, and I mean, maybe there's people that are successful with it, but I would find it hard to believe that any sort of a creditor would be like, okay, take this before the judge and say that you're the original Social Security birth certificate creditor, right? So again, this is not a wheelhouse. I don't know, maybe
one other
successful cases, but go ahead, Rob.
Sorry, one other quick thing. I think let's go, like, if you would just take 30 more seconds here, let's go dive all the way into it. I think we can dispose of it just on its face. When you borrow money in the form of a mortgage on your house, the house is the collateral, not the creditor. The bank is the creditor. So to the extent that you and your social security number are the collateral, you're still not the creditor. So I don't understand how that would, like, even if like you got a lawyer to go, yep, that's a correct theory, it still doesn't help you because the creditor is still the creditor. And if you're the collateral, you're still just the collateral. You're not the original creditor.
Yeah. And there's the old expression, something that proves too much proves nothing at all. And so when we say, well, because I own my name, then no debt is valid against me. Well, if that was true, then our entire economy falls apart. So I'll mention this. Back in the Great Recession, we had a number of lawsuits against mortgage companies, not particularly mortgage companies, but these trusts. So all the mortgages were packaged up, they were securitized, they were sold. There were a number of requirements that had to be met for these packages of loans to get into this vehicle called a trust. They often did not do that. And arguments were made, all these mortgages are invalid. It doesn't even matter if it was true. Judges were not going to say, you know what, I'm going to wipe out all mortgages and crash the entire economy into a deep depression and we'll go back to the Stone Age. No judge is going to do that. So you go back to what Stephen said, is this the best thing you have? Well, I can tell you from looking at uncountable number of credit reports over 20 years of suing credit bureaus, almost every negative account has errors on it. You don't need to use this sort of stuff. You just go in there and you say, is all the information accurate? Is all the information complete? The answer almost always is going to be no. You now have a legitimate basis. You give the credit bureaus a chance to fix it. They fix it, great. They delete it, great. They don't do either one, you look at suing them. And so, sometimes people, whether they're being legitimate or whether it's to sell some, $1,000 book, they have you sort of go all the way around the world when there's this very simple path of, is it accurate? Is it complete? let's see here. We've got Alaya from, I think, our last legalese. Thank for assistance with DirecTV. So I do want to talk about this for just a second, because this is a very, very common thing. You look on your credit report and there's a debt collector. It's IC Systems, it's Enhanced Recovery, it's AFNI, and it's this $100, $127 DirecTV, AT&T, Charter, Spectrum, whatever their name is tomorrow. And you're like, what in the world? I paid my bills. And if you call the collector, they go, oh, well, you didn't turn in the equipment, or that was a cancellation charge, or whatever. A very simple solution, which sometimes works, is you call Charter, Spectrum, AT&T, DirecTV, and you say, hey, look up under my name, my social, my former addresses, look at all my accounts. Do I owe you anything? A lot of times the answer is no. Well, let's think about that for a second. The original creditor says you owe nothing, but IC Systems, AFNI, Enhanced Recovery is telling the world on your credit report that you owe $173, $115, and that tanks your credit score. Well, we have this thing called the FDCPA, Fair Debt Collection Practices Act. They're not allowed to lie, even on your credit reports. So we sue the collector. And then we may file arbitration against the AT&T or Charter or whoever, because they admit you owe nothing, but they sent the account out to a collector. So make that phone call. I certainly can't give anybody advice. I'll say for my clients who make those calls, when the phone is answered, talking about phones, Robert, when the phone is answered and says, please be advised, all calls may be recorded. Okay. They said, I may record the call. So you record the call, and you can put yourself in a really good position. So this is something that, a lot of people discover about 6 weeks before they're closing on a house, when their credit score goes down 100 points because of this. And, maybe you do owe it. And if you owe it, you can pay it, usually get the collector to delete it. But if you don't owe it, you don't need to be paying, blackmail money here. You need to make them pay you money. So let's see. We've got Sam, mortgage is 9/10 of the law. That sort of looks like Donald Trump a little bit. I don't know exactly what that means, but okay. Let's see. Dwayne says, I need help during my forbearance. I was 30 days late. I made payment bring account current. Company still reported me late for a year and a half afterwards. So I'm assuming this is probably under the CARES Act, that we could get a forbearance, or what the law calls an accommodation.
Mm-hmm.
Yeah. The deal with that is, when you get that accommodation, it could be a forbearance, it could be a loan mod, whatever it is. We sort of take a picture of you at the moment that you get that accommodation. If you were current, they have to report you as current all the way through that period of accommodation. If you're 30 days late, they're supposed to report you 30 days late. And so it sort of freezes you during that period of time. So if later you bring it current, that would not necessarily, unless they told you it would, not retroactively go back and bring you current all those months that you were 30 days late. So, Dwayne, I would say look very carefully at what, I presume this was a mortgage company, what they told you about, hey, if you bring this current, or here's the way we're going to report you. Because sometimes they will say things and then do the opposite, and that can be helpful. Let's see here. We got obviously talking about Stephen and Robert there. So here's an interesting one, and so I'm looking at this. I have never seen this before. So Equifax denied many times to investigate the credit report of my clients, since their Social Security card shows valid to work only. I'll be honest, I didn't know Social Security card said that. Is this legal for Equifax to deny an investigation? So I guess my first question to you two is, what is this about the Social Security card and valid to work only?
That's probably not a
Well,
social security card. It's probably an EIN or some kind of other card for a foreign person to work in the United States, but not necessarily have a social security card.
well, I mean, yeah, I mean, so, all right, so I guess let's kind of to your original question, John. So when you send in disputes, the CRAs are supposed to have reasonable procedures to verify your identity as the consumer. So if the consumer has a social security card, so then the question is okay, if the card itself, is the card only valid or is the number only valid? Because there's an underlying human being there, right? So if the card says valid for work only, then that means that the social security number, I mean, that sounds more like, so I've seen that before, but then the question is, can the bureaus kick that as a valid identifier? Because the bureaus are not an employer. I guess that's kind of where I'm thinking. But then on the flip side, the bureaus are supposed to have reasonable procedures, right? And so, I mean, if you send them, which is clearly a legal, legitimate social security card, even if they're not the employer, how can they kick it back? So I guess kind of my first question to this post is, on the Equifax response, does it specifically state we reject your social security card because it says valid for work only? If it states that, I would be interested in you sending that over to one of us here. And if we can find enough people like that, I think one of our class action guys may want to take a look at that, because, I mean, if it's a valid copy of if it's a legitimate copy of a valid social security card, and then to your point, Robert, even if it's an I-10, I mean, they may have a credit profile under their tax ID number, right? And so I guess that's kind of, how can we prove that that's why it was rejected? Did their kickback letter specifically state that? If so, try to send it over, redact it, but send it over to one of us to take a look at.
Yeah, there's no requirement that you send a social security card.
That's right.
Probably 1 out of 100 disputes that we make at my firm do we include a social security card. Here's a driver's license. Some people don't have a driver's license. They have like a state ID. Here's an ID. Here's a passport. It doesn't really matter what it is. It's just to show that you really are who you say you are.
Mm-hmm. Yeah.
And whether it says you can work or not work, or to me, none of that matters. If Equifax is rejecting it, and this is really that person, whatever their name is, they really are making that dispute, and sufficient proof has been given to Equifax, and Equifax just rejects it, that's a big problem for Equifax. And there is no, 10 commandments of what they require. It's just, it has to be sufficient proof. So, here's a utility bill or a bank statement or something that has my name, my address. Here's some type of ID that I have. I mean, it might be a W-2, or, there's any number of things it could be. So I would be very, very interested in seeing that.
Let me ask you this, John. So if, let's suppose underlying dispute that he has is a good dispute, lots of factual information in there, and let's suppose the Equifax document states this was the specific reason they refused to reinvestigate, would this be potentially a case-worthy type scenario in your opinion?
It may be. A lot of times when we see something like this, we'll give the bureaus another chance, because almost always they will just send the exact same form letter they sent the first time. And so when you write, like you take your dispute letter and you write across the top, second and final notice, here is my, social security card or whatever my proof of identity is. And then they write you back and go, well, you didn't provide your proof of identity, so we're rejecting it. Then we take the position, hey, your 30 days to investigate is gone. You completed your investigation, which means you didn't notify the furnishers. That violates Section 1681I. We told you about the problems. You didn't fix them, so you don't have reasonable procedures to assure maximum possible accuracy. That's the EB claim under Section 1681. And this is not an accident. This is willful. You intentionally refuse to investigate, and when we get willful, then we get to punitive damages. So a lot of times when they send these sort of bogus rejections, we do follow it up and say, here's your last chance. I will highlight something Stephen said. It needs to be a legitimate dispute, not the, prove or remove, or you don't have my name in blue ink, so it's invalid. I mean, here are the factual issues. Here's the inaccuracies, the incompleteness. And then when they reject those legitimate disputes, now you've got the Bureau in a very challenging spot because they put themselves there.
John, quick question for you. So obviously you don't even need a socials to have a credit profile, and you do need to prove who you are in order to do this dispute. I'm wondering if, and I'm just reading into this here, it says social security card, not EIN, not anything else. And then it says, they marked it as, the card itself says valid to work only. I wonder if in the dispute they said, here's my social security card, and that it's not a social security card. And then Equifax saw it as some kind of, not fraud, but some kind of illegitimate identification. Thoughts on that, maybe?
Yeah, it could be. I mean, we need to be precise. And, I don't know if this dispute was sent in Spanish. The credit bureaus will certainly give you your credit reports in Spanish. They're obligated to do that. I would say that they are not, they're not particularly skilled at processing disputes in English. I think they're even less skilled at processing disputes in Spanish. And so it may be that they're misinterpreting the letter, but we would just want to make sure that what we say, like if we say, here's my social security card, that really is our social security card. And if it's not, then, and whether this is English or Spanish, we just want to make sure we're accurate in our letter. So let me see. I think if I can find, let's see, class actions. Yeah, it could be a class action. I'll say for most people, a class action really only serves the lawyers. It's much better for individuals to bring their own cases.
But so real quick. So obviously, El Canal de Credito, he's a Spanish gentleman, probably have a Spanish market. He's sitting here saying this is kind of a pervasive issue. And so probably the underlying reason why the social security card would say for work only is they're here on like work visas, right? I mean, that would probably be it. I mean, and to your point, John, I mean, I obviously class actions generally take years and the lawyers make all the money. But on the flip side, though, I mean, if there's something truly here, then you got the whole, I hate to say that, but I mean, kind of the minority, are the bureaus making it harder? Because here's El Canal de Credito trying to provide a professional service to these poor guys, and they keep on hitting the brick wall. I mean,
yeah,
I'd still be interested to see a sampling of a few of these to whoever El Canal de Credito is.
Yeah. I mean, we certainly see the bureaus are not treating whether it's a Hispanic market or other markets fairly. And what I mean by that is not putting forth any effort or understanding into how names work. Do you take your mother's name? Do you take your father's name? And so they're mixing people up, and they're taking your middle name, making it your last name, and vice versa. So they do that to sort of native English speakers, but we see it more with, if it's a Hispanic market or an Asian market, somebody that might have a name that's not John Smith. Okay. And the credit bureaus, they struggle with sort of the common things, but when it gets a little bit different, we see sort of a lack of effort there. So let's just see if we can get some more information there. We'll try to bust through these quickly here.
John and Steve, I gotta take off.
Okay. Well, thanks for joining us with zero notice, and you did a great job. So
thank you. I appreciate it.
Let me just
Thanks, Rob.
Yeah, let me just, if you got 1 second there, Rob, let me make sure this is your website, right?
Yep, that's it.
Okay, so just CredZoo, and if you're in the credit repair space, check this out. I'll say this about Robert: he puts a lot of work and effort into understanding the cases, the law. read what he puts out, decide if you agree, disagree, but he's very transparent about his thought process, and I really appreciate that.
I appreciate the kind words. Thank you guys very much.
Okay.
I guess.
All right. So can credit bureaus reinsert at any time a collection account that's been removed? I would say if they removed it without you disputing it, maybe it's easier for them to do it. But if you dispute it, it gets deleted and then they reinsert it. There are some hoops they have to jump through for that. So you just want to make sure, is it the same account, the same collection agency? Sometimes, it might be LVNV gets removed and then LVNV comes back on, but it's actually a different account. So you would just want to be careful about that. Let's see. Why can't people sue creditors when they sell a debt for 5 cents on the dollar, not offer the debtor that deal? Yeah, there'd be a lot of debtors that would take the 5 cents on it. And I'll say this from standpoint of, I've been defending debt buyer lawsuits for many years. The reason that these creditors can do this and debt buyers can do this is it's just the law. Here is an iPhone. I could sell this to Stephen. I probably paid an outrageous amount. I don't know. It's a monthly, it's built into my monthly bill, but what do new iPhones cost? $500 or $1,000 or something. I could sell it to Stephen for $10. Well, now he owns it. Debt is the same way. So they are allowed to do that. The question is, did the supposed debt buyer really buy the debt? And if they did, then they have the right to collect, but a lot of times they don't actually buy it. And let's see, Stephen, this goes back to that notice of dispute. Automatic $100 to $1,000 penalties. I've sent them certified letters. There are also many other factual incorrections. And then there's a follow-up to that. So you have any thoughts about that, Stephen?
Well, yeah, so it's not like an automatic penalty. If you're looking under the FCRA, you're looking under 1681N or 1681O for your negligent or willful noncompliance. And to get to that point all the way through, you have to get all the way to a court case and then, to an actual decision, right? So anything before that is, even if you go through a case and you settle, you're not necessarily going to get with 1681N or O say, because you're going to settle. So, at the end of the day, yes, that's what the FCRA would say would be the damages, or, which you can recover, but you've got to go through the process to recover that. And that's kind of where the challenge is.
Yeah. And for some reason they did it this way. I wish they had not done this. 1681O is for negligence. 1681N, which should be the one for negligence, is for willfulness. So if it's only negligent, you get actual damages. If we go to the next section, the previous section, N, this is for the willful noncompliance. And here's where you can get, actual damages or damages of not less than 100, not more than 1,000, but it has to be that willfulness. So you can get that, or you may not, it's just going to depend. There is something else that, Stephen, I wanted you to take here. Using factual disputes to remove items, but I've heard the future is Metro 2 compliance disputes. Seeing what they look like, but do they actually work? Could I use them along with factual disputes, hit the credit bureaus from a different angle? And then thanks for your help, guys. You're very welcome, Robert. Very good questions, by the way. So, Stephen, in your mind, Metro 2 compliance and factual disputes, are those the same thing? Or are they first cousins? Or are they totally different?
Yeah, sure. So, there's kind of different folks that have different things that they kind of say Metro 2 compliance is or whatnot. So kind of how I look at it, Metro 2 is the industry standard for reporting accurate information. And information is the data, right? So what I do and what I teach folks and what I practice is we use Metro 2 really as kind of the set of rules for why it's accurate or inaccurate. I think there's some other folks that say, well, Metro 2 compliance is some other thing, that's trying to see if they forwarded the dispute or something. I'm not even really sure if I completely understand how they can send a dispute that's not really a dispute. But from kind of what I look at as it's the set of rules essentially, right? And so for me, Metro 2 is really just it kind of bolts on to the factual. What's wrong with it? It's the factual data. Why is it wrong? The Metro 2 is why it's wrong, because it doesn't perform to their standard.
Yeah, and when we say Metro 2, people describe it different ways, but that's the format that the information comes. So if you think about it, there's 3 credit bureaus, the big 3. I mean, there's hundreds of other credit bureaus. And I think they have around 10,000 furnishers that supposedly every month submit information to the credit bureaus. Well, Capital One has their data stored a certain way, Bank of America another way, Portfolio, LVNV. And the bureaus say, we don't want it 10,000 different ways. We want the standard sort of language to be used. This is probably a bad example, but it's sort of like a PDF, right? A PDF, any computer can read that versus, well, maybe this is a Mac only or a Windows only. No, it's, anybody can look at a PDF on any device. So when we talk about Metro 2, we're saying there are standards that are laid out by the industry about here's how you report this. And I'll give you one example, a 30-day late. Well, the standard is 30 days means at least 30 days late. Well, what if you're 29 days late? Well, then you can't report 30 days late. Now, we don't need Metro 2 to tell us that. We can figure out that 29 ain't 30, okay? But it's helpful when the industry says, oh, and by the way, guys, you cannot report somebody 30 days late unless, shockingly, they're actually 30 days late, okay? So these things sort of fit together, they merge together. And I would just say, just as a caution, be wary of somebody who says, come over here into the dark side of the alley here. I've got the secret sauce nobody knows about. I've got the magic letters if you pony up the money. There are no magic letters. Any type of letter can work. You can send on purple paper with green ink that says prove it or remove it, and you may get an account removed. It doesn't mean that's a good way of doing it, okay? You can jump off a 3rd-story building and not break your legs and go, see, gravity's no problem to me. Doesn't mean you should do it again, or you should tell your friends or your family to do it. But just understand that all of this comes down to inaccurate information, incomplete information. That's what it comes down to. Let's see here. Let's see. Oh, maybe this was, let's see, is a Social Security card Daca. So Daca is that's the dreamers, right?
Yeah.
If I'm remembering right, the minors who were here in the U.S. and I know that's been sort of a political football going back and forth, but I would say if you have some form of government ID, whether that's from the state, that's from the federal government, and you submit that and there's a credit report on you, the credit bureau should accept that unless there's something very unusual going on. And let's see, Carlos says, Social Security card is for people like Daca, temporary protection, asylum, it's legal.
Well, I mean, even regardless, I mean, if it's a legitimate Social Security card that validates their number from the Social Security Administration, none of that should really matter, the underlying status, so to speak.
Yeah. So, and this goes back to the CARES Act. So credit reporting, if client brings account current, the account should reflect from that date. So without us looking that up, my memory is it's from the date you bring it current. It's not that it would retroactively. In other words, let's say I'm 30 days late on my mortgage. I get a CARES Act forbearance, and that goes for 12 months. And at month 11, I send in a payment. My understanding is they don't have to go back retroactively and say I was current the whole time. I will say there's a decent amount of of uncertainty about exactly how this law will be applied by the courts. So, just keep that in mind.
Well, and with that though, there's no private enforcement for this right here anyway. So this would have to be a government type action, right? Right, John?
Yeah. So 1681 S2A, you can't sue for that. Now we tend to take those things, we dispute through the bureaus, and that's section 1681I. The bureaus notify the furnisher, and now the furnisher under 1681 S2B has to investigate. So we kind of can bring it in, but like I said, the CARES Act, there are some different views on that. Let's see, going back to our Equifax, teaching attorneys for years, nobody wants to take these cases. Reach out to Stephen or reach out to me about that. I think we're both interested in knowing more about what's going on there. Let's see, got a letter from a credit collector asking for $50,000 on behalf of State Farm. I was in an accident where I was underinsured, $50,000. So a couple things about this. You should, okay, if you're underinsured, that means you did have insurance. So I would definitely notify your own insurance company. Maybe that's Allstate or Geico, and say, hey, I'm getting this. Can you help me? Probably the answer is no. Frankly, they should have probably made sure when they settled the case that they tried to protect you as best as possible. But putting that aside, most courts say that this type of debt is not considered consumer debt. So the FDCPA, Fair Debt Collection Practices Act, does not apply typically to what we call torts. So torts would be like negligence, recklessness. So if you ran through a red light, hit somebody, and they're suing you, normally the FDCPA does not apply. I would definitely get with your own insurance company, see what you can do. They may tell you they can't help you, but they may give you some help on that. It's a tough situation. I'll say that, my background is doing personal injury. So I started in 95 doing personal injury. Sort of the unwritten rule back then was we never went after somebody's personal assets. In other words, if they only had this much in insurance, that's as high as we would go. We broke that rule twice. Both involved drunk doctors who killed kids who were riding bikes. And then it's weird because two different doctors, and both doctors fled the scene. And these are unrelated incidents. And they went to like their beach house or their farmhouse, sort of sobered up and said, oh, I thought I hit a deer. My conscience was totally fine to say, we're going after your personal assets. But that sort of unwritten rule doesn't exist anymore. I mean, you can be 90 years old and most personal injury lawyers will say, yeah, I'm going after your personal assets. So you may, if you have stuff at risk, you may want to talk to a bankruptcy lawyer. It depends on your state. Is your house at risk? Are your wages at risk of being garnished? Your bank account? So I would talk first to your insurance company. If they can't help you, then maybe talk to a bankruptcy lawyer. Let's see here. TCPA violations every night for over 90 days. 3:30 a.m. Email notification, disputed debt, not reported, cease and desist. Case still ongoing. I've mentioned it. So I am not sure about that. Maybe reach out to me directly or to Stephen, and I'm not following that exactly here. Let's see. Wells Fargo got a big lawsuit for denied credit for Social Security valid for work Daca. Okay. Yeah. So it sounds like companies have to respect I guess there's some identification card for the dreamers or whatever. And it sounds like that has to be accepted. This is going back to the car wreck underinsured. Thinking of either just doing nothing, let them take me to court. Best option is bankruptcy. That may be, it's the challenge is you get a $50,000 judgment. Let's say they sue you. if they see you get a judgment, that judgment will likely grow with interest. They may can garnish your wages, your bank account, put a lien on your property. Now, if they're not going to sue you, and it's just a collector who says, I'm going to write you letters and put this on your credit report, well, eventually that will go away. It'll be too late for them to sue, too late for them to credit report. So I would try to get a sense of how likely is it in your state that you will be sued for this. There are some states where, I mean, man, they will sue you like crazy. Typically, this is called subrogation, where the insurance company has paid out money and now they're coming after you. Or it may be the injured person is threatening you. But just find out if you're actually likely to be sued. Let's see, Stephen, in your state, statute of limitations 4 years. Does it count from the time you defaulted the original creditor, from the time a debt buyer took over the account, like Midland Funding? That's a very interesting question. How would you answer that, Stephen?
Yeah, well, I mean, it would be from the breach of contract, I guess. I mean, so there would typically be the default. Now, one thing I'll point out is that if you have a note, that note statute is 6 years. But non-note type credit, typically what you'll see is 4 years for the most part.
Yeah, that's a really good point. Every state has different sets of time periods. And a lot of times people just sort of do a quick Google search and there's a chart and it says, Alabama's 3 years. Well, some stuff is 4 years, some stuff is 6 years. And I've had consumers say, no, but the chart says 3 years. Well, the chart's not the law. The chart is what somebody says the law is. And so you definitely want to know what your statute of limitation is. And I don't practice in Texas, so I can't tell you, but I think what Stephen said is right. It's normally going to be when that contract is breached. If Midland truly bought the debt, then they step into the shoes of the original creditor. And so it wouldn't be from when they buy the debt, it would be from when the breach of contract or whatever it might be happened. Let's see. Oh, this is going back to maybe TCPA. Does 1 year to file apply if I've claimed it during the case? So the TCPA typically is more than a 1 year statute of limitation. The FDCPA is 1 year. If you have a lawsuit, I hope you have a lawyer representing you. Get with your lawyer. If you don't, get with a lawyer in your state who does the type of work that you're talking about. There's zero reason to not have a good lawyer representing you in these cases. I can tell you the defense side, they love when people bring these cases without a lawyer, because it may be a $50,000 case that's settled for $5,000. And so you're really sort of, what's the expression, Stephen, go into a gunfight with a knife or something. You want to have good representation, because they certainly will. And let's see here. And we will try to wrap this up, my friend. We're coming up on
people
2
are coming, don't they?
Yeah.
Questions.
Let's see. Being sued for Wells Fargo credit card never got served. Now they have pretrial conference. Can there be a default judgment if not served? So I can tell you in Alabama, which I think is true everywhere, but if you're not in Alabama, you have to figure this out. And I think maybe I remember you're in Georgia. You have to be served, at least in Alabama, for there to be a judgment. Nothing can really happen without being served. Now, if you're not served, the judge may set it for a hearing, basically to say to the lawyer that brought the case, hey, you haven't served. I need you to serve, or I'm going to dismiss your case. So I would definitely get with the lawyer in your state to have them look this up and see, are you in danger? Because you may say, I was never served, and your state may allow them to hand the papers to your roommate who promptly threw them away, and boom, you may be considered served. So being served doesn't mean you're physically handed the papers. There's lots of ways to be served. So a lot of times people sort of equate those two things. Well, if I wasn't handed the papers, I wasn't served, but that's not always true. You have to check your state law. Let's see. Here's an interesting question. Can I sue for illegal repossession of a vehicle? I'm going to give you a super long answer, probably 15 minutes, or I'll just say yes. If it's a wrongful, illegal repossession, yes, you can certainly look at suing and not sound like a broken record. Get with a lawyer who does that type of work in your state. Those can be very valuable cases. I had one time where we were behind. We paid on like December 24th, and the bank was having a Christmas party, and they didn't do anything with the check. And then December 26th, they repoed the car that still had all the presents in it from the Christmas party at grandma's house. And, they paid an enormous amount of money in that case. Okay. So those cases can be very good, and definitely get with the lawyer in your state. Let's see. This is going back to the underinsured. They said they paid out bodily injury over what my insurance covered. So that's in response to me saying, check with your insurance company that provided coverage. It's a unfortunate situation. I will tell everybody, my view is you really should max out your insurance as much as possible, because medical care is super expensive, and somebody can sue you. I remember meeting with somebody. They weren't in a wreck or anything. I was just helping give them some advice, and they were worth about $3 million, no debt, $3 million in assets. And they had like $25,000 of liability coverage on their car. And I'm like, everything is at risk. Like, go get an umbrella policy. It's $100 a year at State Farm or something cheap like that. They'll make you raise your rates on your car insurance. It just gives you a lot of protection. So that doesn't help you, Taylor, but just for future reference, you really want that high insurance. It's sort of the cheap and easy way to asset protection. Or you can go spend $25,000 on elaborate asset protection strategies. But honestly, an umbrella policy and really good insurance gets you 90% of the way there. Let's see. Knows fraud in my mom's car contract. Called a lawyer, wouldn't take my case. Are any lawyers in North Indiana that can help? I used to live in North Indiana. I lived in Portage, Indiana, which is a small town outside of Gary, Indiana. But I don't know any lawyers there. Trying to think. In Indiana, actually, I do know a lawyer. I just can't think of his name right now. I listened to a presentation out in Phoenix or actually in Orlando. He did a great job. Maybe just reach out to me, to my firm, and I'll try to find his name. Or you can go to National Association of Consumer Advocates, and there's a find a lawyer listing there. Do you know anybody, Stephen, in Indiana?
No, I sure don't.
Okay. Let's see. Bank sent me letters saying they bought my contract from car dealer. I sent the validation letter, no reply. They repossessed my car, reinstated. So the question would be, is the bank actually a debt collector? If you're talking about the FDCPA, sending a validation letter, usually we think of the FDCPA. If the bank is not considered a debt collector, then that really has no effect on them. If they are a debt collector, then if that's sent in the right way at the right time, it can stop the collection actions until they validate your debt. So I would definitely get with a consumer lawyer. Again, I know I keep saying this, but get with a lawyer in your state to find out, what your options are there. Let's see. This is a really good question. What's the difference between state and federal when it comes to consumer laws? Does one supersede the other? It's a really, really good question. I'll answer it as quickly as possible this way. In general, federal law is superior to state law. But sometimes the federal law says, like the FDCPA, Fair Debt Collection Practices Act, it says if a state law is more restrictive, then that one would apply, but not if it's less restrictive. And so it could be that your state law applies. Now with the FCRA, Fair Credit Reporting Act, it carves out a few exceptions, like for California, I'm trying to think, maybe New York, but in general, that's going to push aside state law. So it really just depends on each statute. And I will pull something up just to show this. But if you've got some thoughts on that, Stephen.
Well, then the question is whether the state law is more restrictive or not, right? Like that's all subject to interpretation, or you have to know the case law to kind of figure out how it's been interpreted.
Yeah, so like this is the FDCPA. So if we look at this, subchapter is not a null, alter, effect, exempt, blah, 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 except to the extent those laws are inconsistent with any provision. And then it says, how do we know if it's inconsistent? A law is not inconsistent with this chapter if the protection is greater than the protection provided by the FDCPA. So sometimes they say that, other times they say we preempt or we get rid of state law. So it really just depends on the individual law there. Let's see, Dr. G, some creditors say they can come back at you up to 10 years to collect a debt. So there's three things to think about. One is the time period to credit report. And Stephen, that's going to be basically 7 years from when you defaulted and never brought it current, right?
It never what?
And never brought it current.
Oh, that's right. The date of first delinquency. Yep.
So there's credit reporting. So if they're saying you defaulted and we're going to report 10 years later, they're lying about that. The second one is the time period to sue you. Well, that's a statute of limitation. Some states it might be 20 years. Some states it might be 2 years. So that just depends. And the final thing is, well, how about writing you letters, calling you on the phone? In a sense, that's unlimited, but they have to be super careful that they don't suggest that they could sue you or credit report. And if they ask for a payment, some courts rule that they have to alert you by making a payment. You may restart the statute of limitation that would allow them to sue you. And if they don't tell you that, that may violate the FDCPA. So this would be if it's a debt collector. So it could be true what they're saying. Likely it's not. Excuse me. Now we got Muriel, a Better Body Hide. So I think Better Body was on here in our last episode, and so making some good comments. Vehicle crash a few months ago. Insurance responsible paid the body shop. Was on vacation without signed authorization. So that I'll say this. Normally, when you have a damage to your car, you talk to your insurance company, and they say, "Well, take it to this body shop." And they'll tell you what's wrong with it, and then you bless that. If that didn't happen, that's a little weird. I would ask my insurance company and the body shop, like, why did you do this? I'm assuming you're not happy with the work. So remember the power of certified mail, sending a letter to the body shop, to your insurance company to get some answers there. And let's see here. If I don't show up pre-trial, no one else was served, will there be a default judgment? Yeah, that's really going to depend. Get with Steve Koval. He's a lawyer in Atlanta, and I think he can help you with that. Let's see, also be sued by way of affidavit of avoidance. I think be served. Yeah, there's different ways of being served. It can be like in the newspaper that nobody reads. It could be you're ducking us. It could be serving a family member or even a roommate that lives with you. So all different ways. You can be served in an airplane, Stephen, at 35,000 feet. Are you Stephen Palmieri? And you're like, well, yes, I am. They go, great, you've been served. Makes for an awkward rest of the flight if the guy's sitting next to you. But,
I saw this video once where James O'Keefe of Project Veritas was giving a presentation, and he was served a suit while giving the presentation.
Oh, interesting.
ballsy right there. I love it.
Did you see that Veritas video where they had the Twitter guy and he's just like saying all this stuff and he's like, look, we've been warned there's some Project Veritas they're trying to do undercover stuff, and the Veritas guy's like, what's Veritas?
Veritas, yeah.
And the Twitter guy's like, well, if I didn't know you already, I wouldn't be having this meeting, but I know you're not with that group. And he was
I hadn't met you organically. Yeah, that video just came out like 2 weeks ago. But yeah, so it's something like just, like you've been served, biatch, like right there in the middle of the auditorium, Give it up to 'em. I've seen videos of city councils where people will serve the city council right there, right there in the meetings. It's like
it's
the school board. I guess maybe the school board is what it was. So
I don't doubt that. Let's see. I have a collection reporting incorrect, gets removed. Help with my credit repair company, comes back 1 to 2 months. How can I permanently have it removed? I would look and see if it's being removed and then it's the same account is coming back, the same debt collection company. I would look to see, has the credit bureau violated the law on what's called reinsertion. They're supposed to tell you, I think it's 5 business days before they report it again. Hey, just a heads up, Stephen, we're reporting this again. If they don't do that, then you may have a case against them.
Well, but to this point, and you had touched on it earlier, so if this was removed as the result of a reinvestigation, a dispute, there's kind of if they reinsert, but it was previously deleted as a result of the dispute, what they're kind of saying is, well, although we deleted it in a dispute and we couldn't figure out how to make it right within that 30-day period, we figured out how to make it right after the 30-day period, so we're going to reinsert it. But then you're kind of de facto implying your reinvestigation failed, because if you had the information to correct it during the 30 days, you should have. Like, you can't just put it on the side of your desk for like 90 days and be like, oh, let me brush the dust off and then figure out how to reinsert this thing. Is that right, John?
Yeah, we do see that sometimes where like TransUnion sent one of my clients a letter saying, oh, by the way, we kind of forgot to investigate this from 6 months ago, but we did it now. And it's a little late. So let's see here. We're going to wrap this up here. So Muriel says, thank you for what you're doing. Well, we always appreciate you being here.
Rock on, Muriel.
So how many steps does a debt collector have to go through before they can place something on your credit report? Well, they're supposed to investigate, make sure it's valid. The new rules, what's called Regulation F, so if the FDCPA applies, they're supposed to notify you by letter or with a phone call to kind of give you a heads up, hey, we're going to report this. So if you did not hear anything, and if it went on there after November 30th, that may be something. If it was on there before, and this is sort of an open question, I've heard different viewpoints, and then they continue to update it after November 30 and they never contacted you, that may be a violation. So let's see here. Here's an interesting one. How do I object to a debt collector in writing moving my case to federal court? So if you file in state court, they can what's called remove it, take it to federal court. You can't object to that unless they don't follow the rules. So if you sued, for example, under a federal law, they have the right to remove. If you sued under state laws, oftentimes they'll have the right to remove. They might have waited too long or not followed all the process. That's called a motion to remand. So it's in state court, it gets removed to federal court, and then it either stays there or it gets remanded back to state court. So again, if you've sued a debt collector and you don't have a lawyer, get a lawyer in your state to help you with that, and they can do that. Let's see. I've got a question, difference between dismissal with prejudice and without prejudice. So the way I always explain it is, we think of prejudice as a bad thing, right? We don't want to be prejudiced. In this context, prejudice is a good thing. It means that the case is over, it's done. You might see in like a James Bond movie, they'll say, the orders are to terminate this target, Stephen, with extreme prejudice. And it just means, put an end to it. And so with prejudice means they can't refile the case. Without prejudice, it's sort of like they never filed the lawsuit, and they can sue you again if they're within the statute of limitations. So if you've been sued, you want your case dismissed with prejudice so you can't be sued again. Now, if you're the one doing the suing, if you've been paid the settlement, then you want to dismiss it with prejudice, but otherwise, not. But I would assume for most of our viewers, we are talking about being sued. And so we want those dismissed with prejudice. And let's see here. Fidel says, refer me to someone in the state of Illinois. Yeah, check out, let me share this thing here. So it's consumeradvocates.org, find an attorney. And so what you would do is you go here and you put in your state, and then you can put in the type of practice area search, and it will give you a bunch of people, have their phone numbers, website, and you can go to them. So let me back out of here, and I'll put this in the comments. And let's see here. This is going back, Stephen, to our question about Equifax. They re-enter as a new account, different date open as a collection. What do you think about that?
Is it the same furnisher, though? Like, so if it was transferred, if it's a different date open, it would lead me to conclude it was a different furnisher. Maybe it was transferred, and that could be although you think it should, that seems to be okay. Because that's not really, I guess, a reinsertion, although it really kind of is. It isn't, I guess, I think, under the interpretations in the case laws, right, John?
Yeah, so if it's Midland and then it gets deleted and then they supposedly sell it to LVNV who pops on, that's not a reinsertion, at least as courts interpret it. But if it's Midland coming back on, the question is, did Midland violate the law? Maybe. Did the credit bureau violate the law if they didn't give you notice of that? So I'd like to know more details about that. Here's a great question. Is FCRA, FDCPA applied to tax liens? Typically, the FDCPA does not apply to taxes. I don't know that that's universal, but I think in the 11th Circuit, that's true. Now, there used to be on the major credit bureaus public records like tax liens. We really don't see that with Equifax, Experian, TransUnion, Innovis. You might see it on something like a LexisNexis report. That's data, that's information on your credit report. So if it's wrong, the FCRA would apply to that. Do you see any tax liens on credit reports?
No, they haven't reported in a few years. There's kind of like an agreement with the bureaus. It's supposed to be temporary, but no, they have not reported for a few years.
Yeah, so let's see here. Muriel, hit the like button, everyone. Well, we appreciate that. And then this is back to that collection suit, notice of removal. Yeah, so that's the process. Brandon asked, very good question. Is it true you shouldn't dispute too many inaccuracies on your first letter? My approach is I typically dispute every inaccuracy on every account that I want to dispute in my first letter. I don't see any reason to hold back. There was a theory sometime back about you only do a few disputes, only a few errors. I don't know if that was ever legitimate. That may have been circulated to say, Stephen, be patient. You've got 20 accounts we're disputing. We're going to do 3 at a time. So it takes 6 months to get through disputing all of them. And then, I don't know if that's the reason, but from a legal standpoint and from if they don't fix it or delete it, suing standpoint, there's no problem, in my view, my experience, disputing everything. And Stephen, I think you do that for your clients, don't you?
Absolutely. Just put them on notice of everything, man.
Yeah. See, Fidel, thank you for answering my questions. Well, you are very welcome. refer a consumer attorney lawyer in New Jersey. It's hard to find one. Carlos, I was just speaking with
Rachel Kugel.
yeah,
She's up in New
Rachel. I think she practices in New Jersey, doesn't she?
She does, yeah.
Yeah. Check out Rachel. Her website may still be kind of focused on DUI defense. She's a very experienced trial lawyer, and she's moving into and has been filing lawsuits against credit bureaus and debt collectors. And I am pretty sure this is Rachel here. Yeah, Rachel. So get with Rachel, and she ought to be able to help you or refer you to somebody that can.
And you get double bonus points if you drive drunk with your bad credit report to your meeting with her, and she can represent you criminally and for the FCRA.
Yeah, don't do that. Don't do
Just
that.
a joke there, guys. Okay, yeah.
Yeah, absolutely. Let's see. Sent a verification of debt to collector via certified mail. Company policy not to accept certified mail. Well, that's really interesting. How to proceed. I would say if they refuse to accept it, I would take the position if the Postal Service tried to deliver it, gave them the opportunity to get it. I would take the position in my case is that they did get it. And so now whether they're obligated to do anything depends on kind of your timing. Did you get that letter in with what's called the 1692G time period? If you did, and they're supposed to validate before they collect and they start collecting, then I might look at suing them. That's a very strange policy for a debt collector to have. And I'd be curious who that is. Let's see. Miss G. Shep says, what is my recourse if Equifax doesn't allow me access to my file? So I'll give you my quick version, then Stephen can give you his. Under section 1681G, and if you've been sort of in the credit repair world, you'll hear about the section 609 letter. That's kind of garbage. 609 actually, which is the same thing as 1681G, it's just different numbering. It actually is helpful in what you're talking about because you are allowed to have access to your file. And that's what literally section 609 or section 1681G is talking about. So if you've properly requested it, they refuse, and they don't have a good reason to refuse, then you may want to look at suing them under the FCRA for refusing to give you your file. Typically, we see this when it's identity theft or a mixed merge file. So your file is here, there's somebody with similar name, it's mixed together. And then they go, well, I'm sorry, Stephen, I can't give you your file because you can't prove you live at 123 Main Street. And you're like, that's the other Stephen Palmieri. And even though you've trademarked your name or something like that, there could be another Stephen
Palmieri.
And
Stephen Palmieri is a brand. Can you guys believe that? Isn't that something? So my question here, though, would be, Ms. G. Shep, like, did they give you a reason why they wouldn't give you your file disclosure? I mean, did they say, hey, you're like, so, and how did you try to get it? Did you try to go to annualcreditreport.com or one of their direct online portals? And then they were like, sorry, you didn't pass the security questions. Did you write to them and say, please mail me my credit file? Did you call them? Did you call the annual credit report number? So that's what I would be curious. How exactly did you try to get it, and how were you denied? I think that would be kind of important. But to John's point, it is an actionable section of the FCRA. I mean, if they legitimately did not give you your full file disclosure, that's something that John could take a look at.
Yeah, see, Dr. G says, will this be available? Yes. So this will be, on YouTube, and you can find it. Let's see here. Let me just make sure that came through. That's for Rachel's firm. Okay, so Carlos, you've got that. Verbal contract out of state owner who breached contract hiring a property manager in my state. Dissolved all my rights, taking me to court on disputed amounts not reported. That sounds like a landlord tenant. At least I'm assuming that's what this is. So that's pretty state specific. So I would try to find somebody that has experience with that. Let's see, +4 LLC in Nevada. I've never heard of them. That may be, there's a lot of sort of scammy places that are incorporated in Nevada. So
Well,
that
I have heard of them, but I haven't really dealt with them, so interesting.
Yeah, that is. Let's see, deserve a national brand or firm like Lexington.
Well, you never know what the future may hold. That's all we can say. Isn't that right, Brother Watts?
That's right. So, well, guys, we will wrap this up. And great questions. We appreciate everybody participating. And hopefully you found that first part interesting. I know we went into kind of the weeds on some of the credit repair law and some of the lawsuits. But if you are a credit repair company or you're thinking about hiring one, you might find it interesting. Robert Sigmund was on for the first maybe 30, 45 minutes and really went into a lot of detail with that. And let me grab last few questions here. Didn't pass security questions. My ID wouldn't upload properly. Yeah, I would try calling them and writing them a letter, enclose your ID. So sometimes everybody has problems with like annualcreditreport.com. And so, I mean, that's the preferred way to get it. But if it doesn't work, try the phone, try a letter. In other words, before you sue them for not giving you your file, you want to be able to say to the judge, I sent a letter, I tried online, I called, I sent a carrier pigeon, I did everything to try to work this out, and they still won't give me my file. And then the judge typically gets pretty upset with them. And
carrier pigeon, yeah, roll up to their headquarters, and I mean, you actually can show up in person and dispute, actually, right? Because isn't that right?
Yeah, so.
FCRA, isn't there a provision, John, where like they're supposed to have like if you have a disability, they're supposed to have people that can help you or something like that? It's been a while.
I think, was it Innovis that on your credit report, I think they give an address somewhere in here to come see us in person to get it.
Hang out at the Innovis Cafe, get you a cappuccino while we get your credit report ready. Huh?
Yeah. So let's see. Wicked Fisher, issue with enhanced recovery company, 6 months phone calls, refusal to identify as debt collector. So what I would suggest is call Mike Cardoza in California and see if he can help you with that. Mike is a consumer lawyer, but he used to own a debt buying firm. So he knows sort of both sides of this. And let's see, Carlos, appreciate you guys. Appreciate you, Carlos. And
rock on.
All right. Well, guys, we appreciate it. And y'all have a fabulous week. And we'll see you, here in a couple of weeks?
Second and fourth Thursdays, unless John Watts doesn't put it on his calendar, or unless Stephen cancels on John Watts and you guys. So
yeah,
there you go. Just roll the dice. Hopefully we'll see you on the second and fourth, guys.
All right. Take care, guys.